So my topic is all about Rules of Court, Rule 138, Attorneys and Admission to Bar, Section 20, Duties of Attorney. What are the duties of an attorney? The duties of an attorney are to adhere to the sworn promises called lawyer's oath. So ano ang lawyer's oath? Lawyer's oath is not a mere ceremony or formality for practicing law. It is a sworn promises where every lawyer should at all times weight his action according to the oath. It is also an attorney's source of obligation as he become an officer of the court who shoulder an important responsibility on assisting the courts for fair, speedy trial, faster, fairer, and easier for everyone concerned. The first duties of an attorney is to maintain allegiance to the Republic of the Philippines and support the Constitution and obey the laws of the Philippines. So why do we need to maintain allegiance to the Republic of the Philippines and to support the Constitution and obey the laws of the Philippines? Actually, being a lawyer is being a servant of the law. We all know that it is not a right, but a privilege rather, with a duty and burden conditions. The court also said, in the case of Lee versus Tambago, that the first and foremost duty of a lawyer is to maintain allegiance to the Republic of the Philippines, uphold the Constitution, and obey the laws of the land. For the lawyer is the servant of the law and belongs to a profession to which society has entrusted the administration of the law and the dispensation of justice, while the duty to uphold the Constitution and obey the law is an obligation imposed on every citizen. A lawyer assumes responsibility well beyond the basic requirements of good citizenship. As a servant of the law, a lawyer should moreover make himself an example for others to emulate. Being a lawyer, he is supposed to be a model of the community, insofar as respect for the law is concerned. The second duty of the lawyer is to observe and maintain the respect due to the courts of justice and judicial officer. The second duty simply said that as a lawyer, it is our responsibility to obey the laws and promote respect for law and legal process. In Alparoja versus Calayan, the court stressed that membership in the bar is a privilege burdened with condition. It is bestowed upon individuals who are not only learning law, but also possess good moral character. When a lawyer, in performance of his duty, should act and comport himself with honesty and integrity in the manner beyond reproach in order to promote the public faith in the legal profession. The third duties is to counsel or maintain such actions or proceedings only as appear to him to be just, and such defenses only as he believed to be honestly debatable under the law. One of the example of the number 3 duties is the case of Plus Builders Incorporated and Edgardo C. Garcia versus Attorney Anastasio Irivilla Jr. That the court says that good faith, fairness, and candor constitute the essence of membership in the legal. Lawyers are officers of the courts, called upon to assist in the administration of justice. They act as vanguards of our legal system, protecting and upholding truth and the rule of law. They are expected to act with honesty in all their dealings, especially with the courts. The fourth duty
I
is to
think
employ for
the
the
purpose
purpose
of the fourth
of
treatise
maintaining the
is for us
causes
to be reminded
confided to him. Such means only as are consistent with truth and honor, and never seek to mislead.
the fifth duties is to maintain and violate the confidence and at every peril to himself, to preserve the secrets of his clients, and to accept no compensation in connection with his client's business except from him or his with knowledge and approval.
The fifth duties explain that the relation of an attorney and client is strictly personal and highly confidential, and that the lawyer-client relationship involves mutual trust and confidence of the highest degree, irrespective of whether the client is a private person or a government functionary.
Number 6 duties is to abstain from all offensive personality and to advance no fact prejudicial to the honor or reputation of the party or witness unless required by the justice of the case with which he is charged.
In the case of Jose M. Castillo versus Attorney Sabido Padilla Jr., the court says that among the duties of an attorney are: one is to observe and maintain the respect due to the courts of justice, and second is to abstain from all offensive personality and advance no fact prejudicial to the honor or reputation of the party or witness unless required by the justice of the cause with which he is charged. This case simply says that as a lawyer and as an officer of the court, we are refrained to say bobo or kibobo or use offensive words towards the respondent. It exhibits lack of respect not only to our fellow lawyers but also to the court. We should always not use provocative remarks or even manifest hostility during the proceedings because we are an officer of the courts and we should always observe and maintain the respects. Seventh duties is not to encourage either the commencement or the continuance of an action or proceedings or delay any man's cause from any corrupt motive or interest. It is in the lawyer's oath that he will do no falsehood and conduct himself as a lawyer to the best of his ability and discretion with all good fidelity to the court as to the client, means that being a lawyer and being a servant of the law, he will always conduct himself with truth, honor, and never mislead the court. The eighth duties is never to reject for any consideration personal to himself the cause of the defenseless or oppressed. For me, the true essence of being a lawyer does not depend upon the payment or amount of fees given by the client, but to provide a legal service in favor of the in-need or poor.
I think the purpose of the fourth duties is for us to be reminded that being a lawyer is first and foremost being an officer of the court. And being an officer of the court The lawyers owes candor, fairness, and good faith to the court and to the administration of justice. In the People of the Philippines versus Frisco Holgado, the court says that one of the great principles of justice guaranteed by our Constitution is that no person shall be held to answer for criminal offenses without due process of law, and that all accused shall enjoy the right to be heard by himself and counsel. In criminal cases, there can be no fair hearing unless the accused be given the opportunities to be heard by counsel. The right to be heard will be little avail if it does not include the right to be heard by counsel. Even the most intelligent or educated man may have no skills in the science of the law, particularly in the rules of procedure, and without counsel, he may be convicted not because he is guilty, but because he does not know how to establish his innocence. And this can happen more easily to a person who are ignorant or uneducated. It is for the reason that the right to be assisted by counsel is deemed so important that it has become a constitutional right, and it is so implemented that under our rules of procedure, it is not enough for the court to appraise an accused of his right to have an attorney. It is not enough to ask him whether he desired the aid of the attorney, but it is essential that the court should assign one, the officio, he so desires, and he is poor, grant him reasonable time to procure attorney of his own.